understand the legal imbroglio over Article 370 of the Constitution, one has to go back to 1947. Jammu and Kashmir was a hereditary state ruled by Maharaja Hari Singh. The state was under imminent threat of invasion by mercenary forces supported by Pakistan. The Maharaja reached out to the Dominion of India, and India agreed to help, and an instrument of accession was signed between by the Maharaja and the Dominion of India. Now, considering the way that Jammu and Kashmir acceded to India, the circumstances, the imminent threat of war and internal strife, India declared that the people of Jammu and Kashmir should be given a chance, an opportunity to actually decide whether they would want to continue within the jurisdiction of India or find an alternative. So eventually, India said that the people could form a constituent assembly. One, they could frame their own Jammu and Kashmir constitution. Second, they could vote and decide for themselves whether they want to continue within the jurisdiction of India. Now that said, let's cut to 1949. The Indian Constitution came into existence, and only two articles actually applied to Jammu and Kashmir. One was Article 1, which basically said that Jammu and Kashmir was an integral or is an integral part of India, and Article 370. Now let's focus on Article 370. According to Article 370, the centre could apply more and more articles of the Indian Constitution to the governance of Jammu and Kashmir through the President issuing constitution orders. Every constitution order would say that this one more article would apply to Jammu and Kashmir, or that one other right or benefit of through one article of the Indian Constitution would apply to Jammu and Kashmir. In stages, more and more of the Indian Constitution would merge into the governance of Jammu and Kashmir. The other aspect was that what 370 brought in was that it also gave a procedure by which the Parliament, with the prior consultation and concurrence of the state government, would apply its laws, that's the central laws, to Jammu and Kashmir. Now, having kept that aside, there was this particular clause 3 of Article 370, which said that 370 could be repealed or abrogated. And it showed the way out, the mechanism by which Article 370 in entirety could be abrogated. Now, this clause 3 of Article 370 said that the President could issue a notification declaring that Article 370 ceases to exist, or Article 370 is abrogated. But there was a rider. For the President to do that, the President had to have the prior recommendation of the Jammu and Kashmir Constituent Assembly. Now, if the Jammu and Kashmir Constituent Assembly agreed or recommended that there was no need for Article 370, there was no need for any special status or leeways for Jammu and Kashmir, and if it it's recommended to the President, and the President, only then would the President be able to issue a notification that 370 is not required anymore. Over 2 years after the Constitution of India came into existence, on October 31st, 1951, the Constituent Assembly of Jammu and Kashmir sat for the first time. They drafted the Jammu and Kashmir Constitution. They ended the hereditary rule of the Maharaja. But the most important thing was whether the people of Jammu and Kashmir would want to continue within the jurisdiction of India or not. The Constituent Assembly of Jammu and Kashmir dissolved in January 1957 without giving any positive recommendation on this question. With no decision coming from the Constituent Assembly in 1957, 370 continued in the Indian Constitution. More and more constitutional orders were issued by the President over the years, over the decades, 60s, 70s and 80s, and more of the Indian Constitution got merged into the governance of Jammu and Kashmir. Now, in June 2018, Then Jammu and Kashmir Chief Minister Mehbooba Mufti resigned after the government ally BJP pulled out. After the resignation of the Chief Minister in June 2018, the Governor of Jammu and Kashmir took charge. In November 2018, the Legislative Assembly of Jammu and Kashmir was dissolved. In December 2018, President's rule was declared. August 2019, a flurry of things happened. One, a constitutional order was issued by the President declaring that all the articles of the Indian Constitution would now apply to Jammu and Kashmir. A second constitutional order was also issued, which said that 370, Article 370 has ceased to exist. In common parlance, it means that no more special status to Jammu and Kashmir. In August 2019, subsequently, after all these two constitutional orders, the Parliament also passed the Jammu and Kashmir Reorganisation Act. What the Reorganisation Act did was it downgraded the statehood of Jammu and Kashmir and carved the state of Jammu and Kashmir into two union territories, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. After the abrogation of Article 370 by the President in August 2019, a series of petitions were moved in the Supreme Court. Now, the petitions were moved by people from different walks of life, leaders, politicians, from J&K, activists, researchers, lawyers. They all had a couple of common questions to ask. The first one was, how did the President of India unilaterally, through an executive order, abrogate Article 370 without the prior recommendation of the Constituent Assembly of Jammu and Kashmir? Now, as you remember, Clause 3 of 370, which gives the procedure for abrogation, says that the President, before issuing a notification for abrogation, should get the recommendation of the Constituent Assembly. Now, the petitioner said that the Constituent Assembly dissolved in 1957 without any positive recommendation on whether the special status of Jammu and Kashmir should be removed or not. So they said that with the Constituent Assembly dissolving without a recommendation meant that 370 had attained a permanent character in the Constitution, which meant that the special status of Jammu and Kashmir was permanent in nature. The second question that they asked in the Supreme Court was, how did the Parliament bifurcate a full-fledged state like Jammu and Kashmir, carve it into two union territories, or some say downgrade it into two union territories, without the prior approval of the Legislative Assembly of Jammu and Kashmir? Now, as you remember, the Legislative Assembly was dissolved in November 2018 by the Governor, and there was no Legislative Assembly. Plus, the abrogation of 370 and the reorganization of Jammu and Kashmir happened during the President's rule, because the President's rule was revoked only in October 2019, 2 months after the state was reorganized into two union territories. Now, these are the two main questions. One, how could you reorganize, carve out a state when under President's rule without getting prior approval of the Legislative Assembly? And two, with no Constituent Assembly available or Constituent Assembly being extinct, how could you abrogate 370 unilaterally? Accused of attacking the principle of federalism by abrogating 370 and bifurcating a full-fledged state into two union territories, the center said that the move was in fact the culmination of a long-drawn effort to completely integrate Jammu and Kashmir into the Union of India. It also justified that the valley has prospered post-2019 after the abrogation. And third, it assured the court that the Union Territory of Jammu and Kashmir will be restored to full statehood as early as possible. On December 11, 2023, a five-judge constitutional bench headed by Chief Justice of India D.Y. Chandrachud upheld the President's unilateral decision to abrogate Article 370 from the Constitution. Chief Justice Chandrachud wrote the lead opinion, and he did it for himself. Justices B.R. Gawai and Suryakant. Justices Sanjay Kishan Kaul and Sanjeev Khanna concurred with him in separate opinions. Firstly, the court said that the state of Jammu and Kashmir did not have any vestige of sovereignty left after acceding to the Union of India in 1947. Then the court said that that Article 370 was a temporary provision and was just a mechanism to facilitate the enhanced integration of Jammu and Kashmir into the Union of India. The dissolution of the Constituent Assembly, the court said, was not a factor for the president in abrogating the president's power. It did not affect the president's power to abrogate Article 370. The Constituent Assembly or its recommendation was never binding on the president. So the president could unilaterally decide to get rid of the special status to Jammu and Kashmir, the court concluded. The other thing was that the court did not look into the validity or the why, did not go into why the president chose to abrogate Article 370. The court basically said that it didn't want to sit and appeal over the president, and there may have been certain special circumstances which required special solutions from the president's side. And lastly, the court also did not examine the constitutional validity of the Jammu and Kashmir State Reorganisation Act. This was also a specific question which was referred to the Constitution bench to examine. But instead of that, the court chose to be assured by the promises of the center that the Union Territory of Jammu and Kashmir would be restored to full statehood as soon as possible. So what the court eventually ended up doing was that it just urged the center to restore full statehood to the Union Territory of Jammu and Kashmir, and it went on to direct the Election Commission of India to hold Jammu and Kashmir State Assembly elections by September 30, 2024.